In November, Coloradans will decide if people accused of first-degree murder should be held without bond. And if you're thinking, isn't that like a decision for, I don't know, a judge or maybe a state legislature? Well, yeah, but this is Colorado, where citizen-led efforts change the state constitution all the time over all kinds of issues. Our Kelly Rinke looks at how the state Supreme Court opened up bail to every suspect and how Coloradans could change that.
We need the Constitution to conform with what we want it to be.
This week, state lawmakers passed a resolution to fix another bill's unintended consequence.
When the death penalty was abolished, we were left with a situation where no first-degree murder was a capital offense.
Last year, the Colorado Supreme Court ruled that now that the death penalty is gone, the state constitution gives everyone the right to a bond.
The district attorneys, all 22 of them, decided that this was the priority measure.
Jessica Daughter advocates for policy on behalf of district attorneys across the state. They supported this measure so people accused of first-degree murder could be held without bond. Lawmakers said yes, and now Coloradans will vote on it in November.
When you're accused of first-degree murder, you shouldn't be able to make bail no matter how much access to funds you have, just because of the degree of community safety that comes with that sort of a crime.
Since the Supreme Court ruling, judges have set sky-high bonds, but some defendants have been able to pay them. A man in Aurora accused of killing a teenager paid $500,000 to get out of jail. In Denver, a woman accused of shooting a 16-year-old paid a $200,000 cash or surety bond. In that case, prosecutors have requested $5 million cash only.
Right, suddenly it became like any other case where the judge had discretion to determine what sort of bond to set.
District attorneys and lawmakers think this crime should be treated differently.
For safety reasons, to uphold the victims' rights.
But now it's up to voters to make it official.
More than 500 murder cases have been impacted by the Supreme Court ruling. A person can be held without bond if the measure gets 55% of the vote.
The astronomically high bonds that are being set by judges are essentially no bond at all. So, so what do defense attorneys think about a different approach?
They like this measure because it will allow for a hearing for a judge to see, is there enough evidence to actually hold someone without a bond? So now they'll have an opportunity, if this passes, to kind of make that argument, whereas of right now, their clients can't pay it. They're kind of stuck.
End of story. Kelly Rinke, thank you.